Good
Hi,
afternoon,
everyone.
and thank you for joining us today. I would like to welcome you to Fortney Scott's 2022 Workplace Agenda webinar series. I would like to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's topic is pay equity and DEI&A, a new horizon. Our presenters are Fortney Scott attorneys David Fortney, Nita Beecher, and John Clifford. I will now turn the program over to today's moderator, David Fortney.
Good morning, everyone. How are we doing? So great to be with all of you again today. And Valerie, thanks for that intro. We're so anxious to talk about some of these issues, Valerie. I almost jumped the gun there to begin with, but this is really the second. We have 5 webinars that we are featuring in Q1 to help our clients really get oriented as to the issues that we're going to see before us in 2022. We also regularly discuss these issues on our podcast, DC Insider, What Employers Need to Know. I would encourage you to check it out. That's something that we pretty regularly update and unpack a lot of these topics in much more detail. So today, what we want to do is talk about pay equity, diversity, equity, inclusion, and accessibility. And let's just jump right into it because we've got an hour with you and we want to make full use of the time. I think most of you do know us, but for those that don't, we are, of course, Washington, D.C. We're very proud that we're a woman-owned law firm. Our practice focuses on exactly what we're talking about today. The federal agencies involved with the EEO issues and, of course, the labor board. And we bring significant experience in dealing with these issues, both in the private sector, and a number of us also have had government postings, so we try to add that element in. Well, let's talk about the agenda, because I think that's where we really can move into the meat. We first want to talk about some of the trends. This is really going to be kind of a quick recap. We then want to talk about the federal efforts, because this is where it's beginning to move. We have the new agency leadership and the Biden administration starting to really say, how can we leverage corporate America's diversity efforts and get those going in a direction of focusing on compliance, which is terrific. And of course, trends in pay equity, some of those not completely trending favorable for employers, but nonetheless, ones that we need to be aware of. All right. Well, let's start quickly with the DEI&A trends. Now, I just would note that acronym, which I find a little awkward, not because of the content, but the other day at the OFCCP EEOC webinar, they kind of rejiggered it. One of the speakers did, and it should be IDEA, I-D-E-A. And I kind of like that because it's more pronounceable. It does not, I don't want to get into the debate as to which of those letters belongs first or doesn't belong first. That's a very tricky one, but DEI&A, AKA IDEA, IDEA, let's look at the trends and a little bit about what's going on. So John, the road to Hades is paved with good intentions, and legal guardrails still have to be part of this discussion. Let's talk about those.
Absolutely, and David, as we're going to discuss in the subsequent slides today, employers are facing mounting pressure every day, both internally, externally, to step up their DEI&A initiatives. But we did want to take a moment at the beginning of our presentation day just to give a reminder that before jumping into those new initiatives, employers need to keep in mind those legal guardrails for developing and implementing these diversity efforts. The starting points you can see up on the screen here are Title VII, as well as Executive Order 11246 for federal contractors. And as we know, these prohibit employment discrimination on the basis of race and sex, among other categories. So what does this mean for DEI&A initiatives? First, I think maybe obvious to some people, or many people may be well aware of this, but going back more than 40 years now, the Supreme Court has been clear that any initiatives that utilize quotas or make employment decisions squarely based on an individual's protected status are unlawful. That's regardless of an employer's good intentions, whether they're trying to improve the diversity. Those are just forbidden ground. You cannot go there. But what we wanted to touch on a little more today, and where there is some more gray area that employers encounter, is that those prohibitions have expanded over the years to include other voluntary affirmative action plans, specifically ones that may use a protected status, including race or gender, as a quote-unquote plus factor in making employment decisions. So it's not the deciding factor, but for instance, if you have two applicants who are otherwise equal, one who has that plus factor may get the bump to be hired or promoted in some cases. Oftentimes these are referred to as race or gender conscious decisions, but the Supreme Court again has addressed these, and with the exception of some really limited circumstances, these types of programs have also been found to be unacceptable under Title VII. And again, just to quickly touch on some of the circumstances that might make those types of programs allowable, you would have to be able to show that you are remedying an inequity, whether it's gender-based or race-based, that it's temporary, and that your plan is not putting out one group, that you're not helping one group at the significant expense of another group. So again, that can be a high standard to meet, and most employers likely would not be able to fall into those buckets. So quickly, I'll just touch here on, we've talked about what's not permitted. What is? Title VII does not prohibit employers from developing or implementing initiatives that are designed just to provide a fair opportunity for everyone, regardless of race or gender, as long as they don't cross the line, again, into that race or gender-based decision making. This might include expanding candidate pools, or another thing that has been approved of a number of times is setting aspirational goals for a company. So that's our 10,000-foot view of these legal guardrails to get us kicked off here. But I'll slide it over to Nita to talk about some of the fundamentals with those guardrails in mind.
And I think, John, the real point here is that there are lots of things employers can do. It seems to me sometimes they jump to, oh, well, let's look at the numbers, and we're going to give everybody, they need to meet certain numbers. And obviously, if you're a federal contractor, you have goals, and that's all laid out in the federal regulations for OFCCP. But there are a lot of other things that employers should be doing just to make sure they're getting the right employees and making sure you don't have barriers. And so I think these three things on this particular slide: one, look at your compensation practices and strategies. We know that many states now will not allow employers to ask what people are making, for example. And so it's important to judge jobs based on the job itself, not what somebody made at the prior job. And for many, many years, that's what people did. The other thing is, as you move through your pay practices, make sure that you are not just laying on a percentage, because often what happens if someone is lagging behind in pay, especially at starting salary, as you move along, the gap gets bigger and bigger. So I think each and every part of your compensation strategy and pay should be looked at to determine whether or not you've got barriers to ensuring that you have a diverse workforce. Another area that we see a lot of issues around is that for years we've known that often, for example, women do better on performance management. They end up with higher ratings but less pay. So I think that it's important for you to look at, do your ratings for women match what they're getting paid? And I think that's an area where a lot of employers have left managers, and a lot of it has to do, and David and I go back a long way to when people had much more in-house HR staffs who really controlled a lot of this data and decided what happened. And a lot of that's gone. Managers have a lot of authority. But with authority, as Spider-Man says, comes great responsibility. And so, if you're going to give your managers the ability to, by the way, it's a great movie. If you're going to give your managers all this flexibility, you're going to end up with issues unless you're going to have oversight for that. And I think annually, because I know many companies, what they find is they feel like they fixed their pay systems, they feel like they fixed their performance appraisal, and the next year they have the same gaps they had the year before after spending millions of dollars. So that's another issue. And John, you mentioned, I think, one of the big things is outreach and recruitment. Don't go back to the same places you already go all these years if you're not getting diverse talent or you're not hiring the diverse talent that you're getting. And what's interesting, David and John, is that when we talk a little bit about OFCCP and the EEOC's new initiative, you'll find that a lot of what we're talking about here are things that they're recommending, and none of this violates what John was talking about around Title VII. This is all things you should be doing anyway to ensure that you're getting the right people, that you're keeping the right people, and that they're not walking away. And so with that, John, I think you wanted to talk about how to measure, because as we know, former OFCCP director Pat Shue properly said, what doesn't get measured doesn't get done.
That's true. That's true. So Barry, let's go to the next slide, measure success. John?
Absolutely, Nita, and you're exactly right. Measuring success is an important part of any diversity initiative that is being implemented. That being said, we want people to be well aware that there can be risk if you don't measure, depending on how you decide to measure these items. You can have unintended consequences, for example, where success is measured, for instance, solely on meeting certain representation or benchmarks in hiring or promotions. Even if you don't have an actual quota, this can be seen as cultivating, essentially, unintentionally creating a quota in hiring managers, whether it's conscious or subconscious that they're trying to be, quote unquote, successful in their performance. The same can be said of programs we've seen and have received some questions about these that tend to tie bonuses or other financial incentives to hitting certain diversity outcomes, or, for instance, hitting certain hiring metrics. Again, these types of incentivizing programs based on outcomes, the takeaway or the end result could be that managers end up making hiring or promotions decisions based on gender or race. As we discussed, that would be in violation of Title VII. But because they have that incentive, they're trying to, do what they can to get those bonuses or other incentives. Even though the employer doesn't intend for that to happen, it is what results. So how can you measure success, or how can you offer incentives if you're dealing with hiring managers or managers in your promotions practice? In our review of different initiatives, we found that the most successful ones that do stay within those legal guardrails are ones that reward based on effort instead of outcomes. Under these types of plans, managers are typically rewarded for leading efforts or initiatives that are consistent with where the employer's diversity and inclusion goals. And I'll just give a couple examples. But if a manager has developed a program to recruit or coach or mentor minority talent, that should be rewarded as an effort to improve diversity. And that's stepping away from did you hire or promote X amount of people? And again, going back to the effort and improving the pool and improving the recruitment that is not problematic under Title VII. We have found that these programs are effective. You avoid some of those risks of those unintended consequences that can come with the more direct link between the metrics and success or specifically incentives, and are something that we have seen an uptick in employers grabbing onto these.
One thing, can I just say,
I'm sorry, go ahead, David.
That I'm struck by, let's be realistic, because often both the lawyers, the compliance people run into this brick wall of the people saying, just tell us what do you want us to do. Give me a number, I'll hit a number, because almost all corporate accountability is structured so that you have, very, very specific targets for whatever,
Right.
that's how performance is done. So these ideas that John has introduced are ones that we think are A, legally sound, B, have proven effective in the field, if you will, that companies have implemented, that do help address the natural desire. And look, many of you are defense contractors and have a lot of engineering type folks. I know what that workforce wants. They want to be told in a highly prescriptive manner, for gosh sakes, just tell me what you want done. I'll make it happen. And they do. That's the reason they work for you, your company, because they're very good at that. So I think that this requires a little nuance, a little messaging, and a little education as to the people that are responsible so that they understand what this means. And I think these are really important points that you can't just have one training session and expect your managers to get it. This requires a bit of a cultural change in most organizations, I think. So
absolutely.
Yeah.
I think that's right. And David, turning to the next slide, with practical recommendations, I think employers, you're saying, David, exactly what we see so often, which is they come up with a number. We want to hit this number. We want to have this many, new hires who are diverse, this many promotions that are diverse, instead of looking at the processes they have. So let's talk about where are your problems? I mean, I think you've got the data as an employer. You need to evaluate that data. Often what you see is that your diverse talent leaves when they don't get promoted. And you can figure out by doing the analysis of your levels that most of the diverse talent and women will leave when they don't get promoted at a certain level, usually manager, that first level manager. It's different for minorities than women. You have to look at your own organization. But that's when people leave. And then you try to fix it by hiring people in who don't know your organization. But I think first and foremost, what's going on if that's happening in your organization, what's going on with your promotions policy? What kind of inclusion do you have? What kind of mentoring? Look at the actual process. Who's involved? What kind of training do you provide to your managers? And do you look at the numbers before they're actually finalized and say, are these the right people to be promoted, or should someone else? Again, you're not doing it. You want to make sure you're doing it based on who's best for the job, but you don't want to lose all that talent that you've spent so much time and effort recruiting and training. The other area I wanted to mention is people often look at involuntary terms, and I think that's important because involuntary terms, especially if you have adverse impact for women or minorities, is where you're going to see the agency's focus. But I think voluntary terms can be just as important because they show management issues. They show that you've spent a lot of time and effort to bring these people in, and they are leaving. And you need to look at that and figure out why. Make sure you have some kind of a process whereby you either do an in-person interview or a survey after, when they're leaving, and so you know what those issues are so you can do something about them. And finally, something that isn't always happening, maybe now in the Great Resignation, David and John, we're seeing more of this, but survey your employees and actually ask them and listen to what they say. Back in the day when I was in corporate America, when people would say, we don't like X, Y, or Z, management would say, well, they don't understand. Well, these days, I'm not sure that's the right answer. Right. Your employees will tell you what the issues are and where there's issues around inclusion and how you're going to keep your best talent regardless of race or gender, but you want to keep those people you spent a lot of time and effort. John or David, any other comments before we go to the diversity metrics?
I had just one, Nita, that I think what you have, that is exactly the roadmap, and good, I'll call it, idea hygiene, to use our acronym, would be that you do this regularly. This becomes part, and I know there's a tension between what we're talking about and a bit of the hollowing out of the human resources and compliance infrastructure that many organizations have. But notwithstanding that, this is really important. And this is what keeps and retains and allows you to grow the talent that you fought and spent so much money and effort to obtain. So it's doing it regularly and then periodically doing a deeper dive in terms of legal compliance back to those metrics that John introduced. Obviously, that would be on a privilege basis, and you really delve into it and you go big picture. But the one's not mutually exclusive. They work together. They're an integrated, holistic approach that will help you chart an effective and sound course. So I think these are really, really helpful points. All right. Metrics for reporting and disclosure.
Sure. So we've touched on what you can do with diversity initiatives, and Nita just went through some of the practical approaches. But if you have implemented or if you are going to implement these types of efforts, what comes next? And what we're seeing is that employers are increasingly being faced with a question of what to do with their diversity metrics, whether or not they publicize that data. More and more employers we're seeing are disclosing in some form their DEI&A data, and this is occurring for a number of reasons. One that certainly makes quite a bit of news is the interest of activist investors, the primary example being Arjuna Capital, who focus on what they term as ESG factors that to put pressure on corporations. And one of those ESG factors is putting pressure on corporations to make diversity data public. ESG standing for environmental, social, and governance factors. But these investors, these activist investors, focus on these different types of ESG, whether it's environmental, whether the company is a steward of nature is the quote that you often hear. Social, the S is how they relate with their employees, as well as their customers, suppliers, and their surrounding communities. Obviously, this is where the push for diversity data really stems from. And as well as I think it also factors into the G in ESG, the governance, which deals with a company's leadership, what executive pay, what are the internal controls. So all of these factor together, and we're seeing these pushes as part of this for companies to release the diversity data that they have available, whether that's submissions, government submissions, which we'll touch on later, or voluntary initiatives for DEI&A. Before moving to some of the other topics that are facing, I do want to just touch on the pretty amazing impacts that some of these activist shareholder initiatives have had just in recent years. Back in 2020, as an example, Google, or I should say the Google's parent company, Alphabet, as a result of a shareholder initiative, a shareholder-initiated lawsuit, ended up settling, and as part of that settlement had I believe it was north of $300 million that they committed to funding and creating a DEI&A advisory council comprised of outside experts. So you can really see the impact that these types of shareholder actions have had. More recently, I know Microsoft has committed as a result of a similar shareholder initiative that was sponsored by Arjuna, in fact, that they committed to reviewing their sexual harassment and gender discrimination policies. So Nita and David, I know that you followed some of these types of shareholder efforts as well and the effects they've had, if you wanted to comment on those or other examples that you've seen.
One thing I was going to mention is under the Trump administration, there was going to be quite a restriction on the ability of firms like Arjuna to focus on these social issues, which around the world are often called corporate governance, outside of the U.S. But I think the Biden administration has flipped that over, and especially if there's a change in administration, not in the House and Senate, that we may see a big fight over whether or not the Trump rules will stay in place, which would require companies only to focus on shareholder value and nothing else.
Correct. I think, to be honest, and I think that those of us that are both on the legal and compliance and human resources and diversity piece of this need to understand that what animates senior leadership are really some of these external factors, and shareholder activism. And Natasha Lamb at Arjuna is perhaps one of the best at shareholder activism. Really result. And there's a number of strategies that can be conducted to help insulate yourself, to anticipate and insulate yourself from those types of claims. But I think that becomes, that's a big gauge on the dashboard as we look at these other things. These other points we've talked about will help you prepare for and be in a position to respond to if you do face that sort of shareholder activism and stepped up reporting that we're seeing, both federal reporting, SEC, as well as state reporting. All right. Well, John, do you have anything else on that topic? Otherwise, I want us to move into what the feds are up to, the federal approach and agencies. And let's just jump right into the newest initiative, the HIRE initiative, as they've called it, which I know the agencies are very excited about. To me, it feels a little bit like old wine, new bottle, but maybe too much of I don't know. The agencies are animated on it. So what's going on with that?
Well, I do think it's interesting, David. So this is, I think the most important thing about this, to be perfectly honest, is EEOC and OFCCP have come out with this new initiative. HIRE stands for Hiring Initiative to Reimagine Equity. Don't you love acronyms in the federal government? But something we really haven't seen much, and David, I know we've talked about it internally and in other programs, is how much we are seeing the federal agencies work among themselves, among and between themselves. EEOC and OFCCP used to look down at their noses at each other and not really pay attention. But because we have the former chair of the EEOC, Jenny Yang, as OFCCP director, and the former vice chair, as Charlotte Burrows, as the EEOC chair now, I think you're seeing they're just much more closely aligned. And actually, to be honest, most of what they're talking about in this new initiative, which basically is a roundtables, they're going to be roundtables, discussions with employers and other stakeholders about how to remove barriers. Now, does that sound familiar with what we were just talking about? This initiative really is what a lot of employers are doing already, but I think the idea here is for the agencies to get behind it and encourage employers to really dig down and figure out ways, basically, according to OFCCP, identify strategies to remove unnecessary barriers to hiring and promote effective job-related hiring and recruitment practices to cultivate a diverse pool of qualified workers. What we were talking about. One of the most important things that we really don't know what they're going to do with is we know that both Director Yang and Chair Burrows are very interested in the use of AI in hiring. And I know, David, you've talked quite a bit with Commissioner Sonderling, who is also very focused on this. This, I think, is an area where employers do need to be careful and understand whether or not they have adverse impact by their use of AI in hiring, because I believe that is going to be an area where we're going to see agency activity. But anyway, I think short term, it looks a little bit like much ado about nothing, or we've already done this. But on the other hand, it means it tells employers what they can expect from the agency. The agencies are going to expect you to be looking at your practices, looking at your compensation, looking at your outreach, looking at your recruitment. And if you're not, you may find OFCCP, if you're a federal contractor, or EEOC come calling.
I think it's a helpful reminder because as companies are dealing with pandemic recovery, responding to the Great Resignation, there's a huge hiring surge going on. I mean, may not be able to hire everyone we need. Everyone's trying to hire. So it's a very timely initiative in that sense. It is a reminder. I do think the agencies will use the bully pulpit to emphasize or highlight best practices, all of which is helpful. AI is going to be a big piece of that. They kind of tuck that in softly. I agree with you. It's going to get very animated. And as always comes with the velvet glove is the lead pipe. We will see coordinated enforcement based on hiring practices. That will happen later this year. It's a given. All right. What about some of the new metrics?
Yeah, there's some new reporting measures that we wanted to discuss here, and at the federal level, what's new? Well, I guess about a year and a half old at this point would be the SEC's human capital disclosure rule that went into effect in fall of 2020, and it requires public companies to report on human capital. Now, if anyone has read the language on what they have to report, you will see that it leaves a lot of wiggle room. It is pretty big for what employers actually have to report. And in fact, the only workforce statistic that has to be reported is a head count. But this has opened another door, another avenue for, we talked about the activist investors, for the public to increase pressure on these companies to release more data, to provide more than that basic head count. And in 2021, there were a number of reports and reviews of what companies did submit, and what was found was that a majority of firms actually did provide some form of diversity data or information. Now, there's a caveat there that most did not actually provide metrics, but limited it to a description of their diversity efforts and their approach to DEI&A. But they at least, likely as a result of that public pressure, clearly it's having an impact in that companies are submitting something, a little more than the bare minimum here. One note on this is that the new chair of the SEC has said that they would propose a new human capital rule, which I believe most people expect would include more specific, more extensive disclosure requirements. So certainly something to keep an eye on moving forward. Yes, Nita.
One thing that I did notice is, I don't know how many people were following the Activision sexual harassment, how shall I put it, litigation coming out of EEOC settlement and so forth. But one of the really interesting things to me, John, as you're talking about the SEC, is the SEC opened an investigation into what Activision said in its reporting about this particular huge, and this is a huge sexual harassment settlement with EEOC, maybe one of the largest they've ever had. So, employers need to be aware that whatever they submit, they may get some pushback, at least in this administration, from the SEC.
Yeah, that's becoming a pretty solid, that's not an outlier, that's a trend line. Title VII compliance, that's why we started with legal guardrails. Failing to meet those requirements then can ripple through all and be animated through all of these other aspects that have been laid out here. All right. Well, I guess not everyone's in complete agreement that these are great initiatives, though. Is that right, Nita? I mean, this is the challenge that companies have.
Yeah. Yeah. Well,
one path that they need to follow, and they're in the clear.
Well, and I think we're seeing there's a lot of pushback right now. Just like everything else, everything's politicized. In this situation, there have been other lawsuits like this. White males, basically, we call it reverse discrimination. It's technically not reverse discrimination. It's still race and gender discrimination if they're being selected or terminated. There was a lawsuit in the Western District of North Carolina out of Charlotte where a white male executive, David Duval, claimed that he and 5 other white male executives were terminated in a 12 to 18-month period because the company wanted to be more diverse. He even claimed that he was replaced by 2 individuals, a white woman and a black woman, because he was such a great performer. He got $10 million in punitives out of that lawsuit. Now, obviously, there's a cap. I don't know if there was in North Carolina, but there's a federal cap on that. So whether he'll get all those punitives is an interesting question. But his claim was that his supervisor had 7 white men reporting to him in 2018 and only 2 in January of 2019. So the numbers did, at least in this case. And I think we're seeing other situations, and David, we're going to turn to you to talk about affirmative action, but I think we're seeing other pushback in the states around the whole critical race theory and some of these others. So employers who are moving out with diversity training and things like that need to stay very aware of what's going on in their particular state.
Yeah, the state considerations, again, Google had the engineer who used a
Correct.
variety of legal claims to challenge diversity training and initiatives, both through the National Labor Relations Board, litigation. So, I mean, these there are not a lot of them, but there's enough of them that I think, Nita, your point is very well taken, that employers, you can't just go crazy and
Right.
think that you're going to ram this through, because most of you have a diverse workforce, and that means that some in the workforce may not fully like or understand what is going on, and there's at least certain forums that will be receptive to their concerns, complaints, and even litigation claims. 10 million is a big number to get in North Carolina.
It's a huge number. If it's coming from North Carolina, I can tell you it's a big number.
Yeah.
But David, I think even more important to everyone is what the Supreme Court did this week.
Let's talk about one of the elephants in the room and jump to the next slide. We want to just touch on, so this is affirmative action. Obviously, it's in higher ed, so it's not Title VII of the 1964 Civil Rights Act. It's Title VI of the 1964 Civil Rights Act. But the largely many of the underlying principles and the evolution of the legal principles have historically been quite closely aligned and intertwined as a practical matter. If you go all the way back in Bakke, which is where the real challenge came, and at that time the University of Southern California had an admission policy that was more quota-like. Ironically, the court in Bakke said, it's the Harvard plan that's better. Harvard touted their plan as the model that should be followed, where it's more holistic. We don't really, it's not a quota. We don't try to make up for past discrimination, but we do sort of take into account, and we want a diverse student body. That's an oversimplification of the Harvard plan. That most recently has been challenged by the Students for Fair Admissions. This is a gentleman named Mr. Bloom who has championed the challenge to these on a wide range and through numerous litigations that we don't really have time to unpack. But what we do have now is Justice Kennedy has left the court. We all know that we have a newly constituted Supreme Court. There are probably at least 5 and likely 6 justices that are unlikely to find that the current view of what constitutes legally permitted affirmative action in higher ed should continue. And they're going to likely roll that back. The companion case, so we have a private school, Harvard, we have a state school, the University of North Carolina. Both of those cases are going to be consolidated and decided. They both have very similar programs where they use race or protected status, if you will, as a factor, but it's not solely a factor, and it's not because of past discrimination, but it's designed to create this diverse student body to enhance the educational opportunity and experience for students in the view of the university. What the claimants are principally Asians who contend that they have been subjected to more rigorous standards because otherwise they would be, according to the university, overrepresented. That is, that there might be too many Asians vis-a-vis other groups. The court is going to decide this, whether they decide it by this June or render a decision next term remains to be seen. We don't know that for sure. I will say, I'm going to put my prediction right out here, right now. I think that Harvard and UNC and those systems, which represent what most higher ed is doing today, are likely to be struck down by the current Supreme Court. Okay, most of you aren't higher ed. Why do we still care a heck of a lot about that? Because many of those same animating principles and the framework and the way that affirmative action is discussed, not to remedy unlawful discrimination, but for holistic reasons to improve diversity, those are many of the animating principles that we currently recognize and follow in employment. And as day follows night, if the university systems are struck, it is highly likely that the challenge under affirmative action, particularly for federal contractors. One other warning point out there, the Supreme Court's analysis 2 weeks ago in the OSHA case. Why are we talking about OSHA in this? Because of the rather narrow reading that this court gave on what the government can or cannot do. And in that case, the government said the OSHA Act did not specifically authorize a national immunization or vaccination program. Well, similarly, the procurement statute does not specifically authorize affirmative action and DE&I, or IDEA, if we're going to call it that now. And indeed, those same arguments can very easily be transported to strike down this. So we don't know, but I think that the discussion of affirmative action, what happens in education is likely to happen in employment, and this could be the beginning of a massive change to what we have experienced for the last 50 years plus. But I think it's a big darn deal. Stay tuned, it's just starting. So, well, with that, let's kind of shift. I want to spend, we've got about 12 minutes here. I want to spend a little bit of time and talk about pay equity laws, because that's the other frontier. And we view this as, if you will, a subset, a part of this. We called it, good hygiene on successful diversity and retention programs. Pay is really important, and doing so in a way that's lawful is really important. So let's spend a little bit of time on that topic, because the government itself is so focused. Now, the states have been pretty active on that.
Yeah, David, the states have been active, and as well, President Biden, the Biden administration has made promises and commitments regarding that they're going to make efforts in the pay equity realm. We're still largely waiting on those, but where we have seen a lot of the movement, as you mentioned, is at the state level. It's the state policymakers who have been taking the lead on these issues. And one area where we've certainly been seeing a trend among the states is in pay transparency legislation. Pay transparency is sort of a catch-all for laws that are requiring employers to provide wage, salary scale, or rate information to either applicants or employees. And unsurprisingly, California did lead the way on this when they enacted their law it was in 2019, I believe. Their law gave applicants the right to request salary or wage rate information once a job offer was made. So the applicants still had to actually request the information before they were provided it. Washington followed suit with a similar law that applicants could again request information. But more recently, what we've seen is states enacting these types of laws, but have added an extra step of making the disclosure of the ranges automatic. Colorado has taken the most aggressive stance here by actually requiring employers to disclose with any job posting, with each job posting, the hourly or salary compensation requirements that go along with that posting. Notably, this applies to any jobs that can be performed in Colorado, which in the current world with remote workers may leave a lot of postings subject to this requirement. There's a couple of other states that have joined this sort of pay transparency trend. Nevada and Connecticut have also made automatic disclosures required. They're requiring those of employers. They don't require that they actually include them in job postings, but once an employee or an applicant submits for a position, they are required to provide that information to them. So you certainly see the state stepping up in this trend. And Nita, I know you had some comments on this as well.
Well, we understand that Colorado has been very aggressive. So employers who are, in fact, posting jobs that can be performed in Colorado need to be very careful. They are going on to LinkedIn, as we understand from our colleagues in Colorado, and checking. So the state is, maybe some of the states are not as aggressive. Colorado is very aggressive.
Mm-hmm. That's a good point.
So I think, let's talk about the EEO1 because I think that has captured, whether folks do or don't have employees in those particular states. And I would add, as state legislatures are reconvening this year, that landscape is changing rapidly. We do a pay equity bulletin each month, just a shout out. John is actually the editor of that. And that's something, if you're interested, let us know. We'll send you a copy of it each month. But we do track those laws very carefully, closely to keep both ourselves and those that are interested apprised. But let's talk about kind of the federal pay data reporting and this potential new edition of EEO1 component 2. Nita?
Well, yeah, David, as you, this is all part of pay data reporting, and it's important to look at what component 2 was, because California and Illinois really roll out of that component 2. And we had the pay data reporting was rolled out by then Chair Yang in before the election, so it was in 2015. It was eventually
that would be
nixed.
EEOC chair.
Right, when she was the EEOC chair. And it was under the Obama administration. It was nixed under the Trump administration, and then a judge reinstated it. So EEOC has pay data from employers based on W-2 Box 1 and hours worked for 2017 and 2018. The Trump administration decided not to renew that because it is a under the Paperwork Reduction Act, they have to have a renewal from OMB, but they have asked the National Academy of Science to review the data they got, determine whether it's worth anything, and provide recommendations for future pay data collection. Considering that Jenny Yang is over at OFCCP and Charlotte Burrows is at EEOC, we can assume that there will be a new pay data report. And David, do you want to talk just briefly about, you provided some input to that NAS expert panel this year, and what are your thoughts on what they're going to come down with?
Sure, be happy to. And Nita, you're not noting that you were part of the expert panel the first time around.
I was.
That expert panel, of which Nita was a member, actually told the agencies, don't do this. The data are not useful. There are too many problems. EEO1 categories aren't the right thing. Well, notwithstanding the National Academy of Sciences recommendation, the then in power Obama administration decided to go forward. So you've given the history of that. Now it's being restudied. So it's kind of like a do-over by the NAS, National Academy of Sciences. I had the privilege of presenting views and reiterated the concerns that I think everyone attending today's webinar has on the utility. The EEO1 groupings do not at all constitute the factors on which we base compensation. They're overly broad. That the use of EEO1, W-2 pay data is not useful. We typically use base pay as the easiest way to do pay equity assessments. But that if you had to use EEO1, you should at a minimum, W-2, you have to at a minimum use box 5, which at least cleans some of the noise out of the system. That, however, does not solve the problem that if you use box 5 data, if Nita and I both earn $50,000 a year, so there is no pay discrepancy, it's worked the entire year. David only worked for 25% of the year for 3 months. My W-2 data is going to be 25% of what Nita's is. Well, that's a false indicator. And there's, particularly in the current uncertain economy, there would be a lot of that. The answer to have all exempt employees simply put the hours worked in or to make assumptions is mind-blowing and not helpful. So particularly when base pay is important. What's going to happen? Prediction. The National Academy of Sciences this time will probably say, because they kind of stack the deck a little bit differently, if I can add that, I think the NAS, based on the quote expert panel they have, will find, yeah, we think collecting this pay data is a great idea, but why don't we use box 5? We'll at least go that far. What will then happen is the EEOC, once they get their new majority in this summer, will implement those new requirements. Employers probably in the first quarter of 2023, maybe in the fall, I don't know yet, we will be submitting our pay data. And of course, all that will be forwarded over to OFCCP, where it will be used aggressively for audit selection and other enforcement purposes. Nita, I don't know, what else do you have on that?
I think that's pretty much it. That was a big change too, David, because under the Trump administration, they were not going to take the EEO1 Component 2 data. The other interesting thing that means is that your Component 2 data will be subject to FOIA, and FOIA is being treated somewhat aggressively for plaintiffs' counsel these days. So, but that's not anything we can really do anything about at this point. But John, I think the really interesting thing is, what did California do when the EEO1 Component 2 was canceled?
Right, and when the Component 2 was canceled, California stepped in rather quickly to essentially, at least for California employers, continue those Component 2 requirements. So, as of now, the California employers, again, matching the EEO1 requirements, with 100 or more employees, have to submit the annual pay data reports that group the employees by, they use the same pay band, gender, race, ethnicity as the Component 2 data that was submitted. In California, they submit to the Department of Fair Employment and Housing, who has made it clear that they will use this data to identify wage patterns and to enforce their equal pay laws. So that was, it seems that when we touch on these state laws, California is leading the way, to the surprise of not many, I'm sure, but they continue to do so here.
The one thing they did in California, and this is what we think the NAS panel is going to pick up, is instead of box 1 of your W-2, they did box 5, thinking that cleans out some of the issues that we had raised, employers had raised about box 1. They had a lot of other issues. But, it wasn't just California, John. Not only California is rolling out this pay collection.
No, Illinois in 2021, their new law, amendments to their Equal Pay Act became effective. They use the same threshold of 100 or more employees, but it's a little tweak on it. In Illinois, those employers that are covered will have to apply for what's being called an Equal Pay Registration Certificate. And to get that certificate, employers have to submit information and certify certain information. They have to submit a report listing employees, again, separated out similar to the California in EEO1, separated out by gender, race, ethnicity categories, and also provide the total wages for each employee. A little additional item in the Illinois law is that employers must also provide a statement signed by a corporate officer or a legal counsel, which, among other things, must certify compliance with Illinois' Equal Pay Act, and that the average compensation for female and minority employees is not below the average compensation for male and non-minority employees. So there is that extra certification level to get one of these registration certificates.
And John, I just would add to that, Illinois does not yet have its regulations or much detail underlying this. So we're working with a number of clients and trying to feel our way through what this is and how it's going to actually be implemented. But yeah, anyone that has a workforce in Illinois, heads up on this and dig into it. Yeah.
And there's just
before we get to final thoughts.
I was just going to mention, those of you who have 40 or more employees in our state contractor in Minnesota also have a requirement to do what's called a Minnesota Workforce Certificate, and you apply for that every 4 years, and every year that you're covered, you have to submit to Minnesota your AAPs based on their their requirements. So it's not as in depth as federal, but it's their way of looking and making sure that you're involved in affirmative action, to be perfectly honest.
And again, our experience in Minnesota is they do pay attention to it there also.
Yes, they do.
Okay. Well, let's go, and everyone attending today, you'll get this deck, you'll get the detail of what we have just covered. So Valerie, let's just sort of slowly roll through these so people can see what's there, and then these will be takeaways. Next slide, the overview of California that we've discussed. Next slide. Illinois, of course, that's the one that's still being built out. They're kind of flying and building at the same time. Finally, Minnesota. Pay attention to that. Luckily, it's every 4 years, but still one that needs attention. All right. Well, gang, we're the sand in the hourglass is running down to the last few grains. But let's leave with some final thoughts so that people have the benefit of that. Who wants to go first?
Well, we have next steps, so.
Sure.
Yeah.
And I know on the next slide, as Nita mentioned, on the next slide, we have next steps. And I think bringing this back to the beginning of these slides and bringing it back to basics as well. I think employers need to review any current DEI&A practice or initiatives that they're considering to ensure that they do comply with the legal guardrails, those Title VII guardrails that we spent some time discussing at the outset of this. And also just take a review of any success factors or metrics that are being used, just to make sure that even if the intent of an initiative is square within Title VII, that there's no unintentional metrics or incentives that may increase the likelihood that managers do use these as unofficial quotas.
Meanwhile, you should really assess your HR practices to make sure that you've eliminated your barriers for underrepresented groups in your organization. And we talked about that in depth. David?
Final thing, the new requirements on pay transparency and pay data collection. Many organizations have been doing periodic pay assessments, which is a good best practice. And you are effective in working with your comp team, your HR, your counsel, doing that on a privileged basis. I think the key thing here is that the landscape on that is evolving quickly. So make sure that your pay practice assessments and monitoring are up to date and comport with what you need to do. So great discussion, both John and Nita. Thank you. And Valerie, I'll let you close us out.
We would like to thank you for joining us today. Next in our 2022 Workplace Agenda webinar series, we will be discussing the Department of Labor's Wage and Hour Agenda. This webinar will be presented on Wednesday, February 9th at 12 noon. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@fortneyscott.com.
Thank you.